Good evening. As many of you know, I'm Raquel Nolasco, the principal at Hillside Arts and Letters Academy, which we refer to as HALA. At HALA, we always want to be culturally responsive to the needs of our students and our community. And we've been able to do this in many ways. We want our students and families to always feel safe. For a very long time, we have tried to create a partnership with an immigration law firm or an individual attorney so that families could get the accurate information and resources they need. But this has been very difficult. Thankfully, we were able to connect with Dr. Jamila T. Davis, who's an author, a television personality, and a motivational speaker, Dr. Angela Pinto, who is the co-founder of Until Freedom and an activist attorney. And they were able to connect the much needed dots to put this event together. So I introduce to you today Dr. Jamila T. Davis and Dr. Angelo Pinto.
Hello, everyone. So happy to be here today in partnership with HALA. So today is going to be an important day because we're going to be bringing you well-needed information and support. And I want you to get excited, not just about today's presentation, but just this partnership and the different access and resources that families will be able to have access to because of it. So without further ado, I'm going to bring my partner to the stage, Mr. Angelo Pinto, and he is going to introduce our guest presenter tonight.
Thank you, Dr. Davis. We're very excited about this evening, not only because we speak to students, parents in the community, but also because we're hoping, we know today we're going to bring a much needed service. So I want to introduce the expert we have brought into the room today, Gordilla, who is a staff attorney at the Legal Aid Society Immigration Unit. She works in New York's Family Unity Project, a universal representation model which provides free legal representation to detained immigrants in New York City. Before joining Legal Aid, she worked as the Prisoner Legal Services of New York and as an immigration attorney for New York State prisoners. Prior to becoming a lawyer, she was an organizer for organizations such as the National Guest Worker Alliance, Missouri Jobs with Justice, the Cross Border Network. She's a graduate of the University of Missouri of Kansas City School of Law and a proud daughter of Mexican immigrants. So I want to welcome Ms. Gordilla into the chat.
Hello, good evening, everyone. Thank you so much for that introduction. It's really a pleasure to be here with everyone and share a little bit of the work that we do, and hopefully this will be informative for everyone. So I'm going to share the PowerPoint presentation that we have set up. And let me just start it. There we go. So yeah, I have been practicing immigration for the last few years in the detained context mostly. And so I just want to give you like a brief overview of what the process is like. So these are the different avenues that you can obtain lawful status. I'm going to go through each of them in more detail, but I just wanted you to see the list of all of these different paths. So the first one is family-based adjustment, and it's basically through the relationship that you have with your family that you are able to gain status. And so you would have to have a U.S. citizen spouse, an adult son or daughter, a sibling, or a parent. You also, those that are not citizens but are residents, legal permanent residents or lawful permanent residents, who have a spouse or are a parent, can also try to get their relative status. Another way is through a visa. If there was a visa that was available, it could be business or visitors at times, or even work. There are different kinds of visas, fiancé visas. But that's outside of the United States, or more commonly, a lot of our clients come here without inspection, meaning that they didn't have the proper documentation to cross the border with permission. And then there's also a interview that is required in this process that also triggers some bars. So sometimes we'll have clients not have status, apply for some sort of status, some application, but then it triggers this consequence because of the fact that they were here without status. So it's complicated, but there are different bars for that. The I-601A waiver of the unlawful presence is available for individuals that are not able to, that have that bar that we were talking about, that the most common bar of the 10 years. And so the good thing about this is that before leaving the country, there's a way of asking the government to give you the answer as to whether or not they're going to give you the waiver. That way you have a better you have a better way of planning out this trip abroad, and going to the U.S. consulate in your home country. You do have to show extreme hardship. So they will want to ask for documentation for that. So, for example, an illness or financial hardship or childcare or something like that. Cancellation of removal is the other option that is available for immigrants. This is only in the context when they are defending, like they have a defensive application. So that's why we have only available in removal proceedings. So my clients usually they'll get detained, and so then we have to defend them against this deportation threat. And so the requirements are that they have to be, they had to have been in the country for 10 years continuously. They have to show good moral character. There's some criteria as to what good moral character is, but as an example, there are crimes that may make you ineligible, and an example of that would be like murder, or if there's some conviction that they define as an aggravated felony. They also have to demonstrate, which this is like the highest, pretty high standard to prove. They must demonstrate an exceptional and extremely unusual hardship to the U.S. citizen or permanent resident, spouse, parent, or child. So basically, they have to have this relative, this relationship with the person in order for them to even be eligible. And on top of that, it can't just be, in order to win, you can't just be that, sort of like a regular hardship. It has to be something more. So for example, health-related conditions, like if someone has cancer, if you're taking care of that person, that's what the courts have seen as meeting the standard, the very high standard of exceptional and extremely unusual hardship. So the next one is domestic violence. There is something called VAWA, which stands for Victims Against Violence Against Women Act. And this is not just for women, so it's also for men as well. And so to be eligible for this, you have to be married to a U.S. citizen or a permanent resident, or if your child is a U.S. citizen or permanent resident, or if you're the parent of a U.S. citizen or permanent resident, and that you suffer domestic violence. So this is one other option that is available for those that have experienced domestic violence. Then we have the U visa, which is for victims of crime. There are certain crimes, so it can't just be any crime. There are, I believe, 26 different qualifying crimes. You have to show that you suffered physical and mental abuse. You also have to show that in some way you helped law enforcement, and this is kind of interpreted a little vaguely. So whenever I have a case and somebody says, oh, I was a victim of a robbery, and they said, yeah, they interviewed me, they asked me questions, like, that to me is a flag that we need to get the police reports, and we have to investigate to see what. It doesn't have to be extensive, so that's the good part. As far as like how much they provided the assistance, so they don't have to have testified, or things like that more formally. It will be valid for 4 years. They'll give you a work authorization. You'll be able to apply for a green card, so for permanent residency after 3 years. And it also includes the great benefit of adding your derivatives, like family members. So if one person was the victim of the crime, say dad, and they have children and or don't have status, then they can also petition for the children. The T visa is for victims of trafficking, human trafficking. So the requirements are that you have to be physically present in the United States as a result of the trafficking. You had to have suffered severe form of trafficking. So usually it's more like physical, psychological, and then they want documentation for that as well. Sometimes we use experts. So even like maybe there is no like photograph or, hard evidence, but we do consult with experts that are able to provide a forensic psychological evaluation to support the trauma that the person has experienced. So they also have to cooperate with law enforcement unless they're minors, or that there's a waiver that just says that that's not something that is possible, and show extreme hardship if they were to be deported. The next category is temporary protected status. So there are certain countries that are designated temporary protected status, or TPS, and it gives them, it's sort of like it's like a kind of voluntary or extension of their stay, and so they're able to live and work in the U.S. It doesn't really lead to any permanent solution for the person. Oh, sorry, that slide is that point is outdated. Depending on the administration, though, it fluctuates a lot. So we've seen that in the last few years, where sometimes we weren't sure if, like Haiti, for example, was going to continue receiving the TPS status. The next category, which is special immigrant juvenile status, or SIJ for short, you have to be basically under the age of 21. There has to be a showing of abuse, neglect, or abandonment by one or both parents. So that's interesting. You don't have to have both. You can just have the one parent that has done this. And you do have to go to like state court, family court, in order to get an order that shows that it is not in the best interest of the child to return to the home country. The child also needs to not be married, and there's certain criminal convictions that could make them ineligible. So that's always a consideration. Then this category is what I mostly practice, asylum. And you have to show a credible fear of persecution in your home country. due to either race, religion, national origin, membership in a particular social group, or political opinion. And these are just some definitions of like what we call the immigrant, depending on at what point they're asking for this relief. So a refugee is if you're still outside of the United States and you're asking to come into the United States. Asylee is when you apply for this within the year of coming into the U.S. But for example, many of my clients have been here more than the year, and so they're actually applying outside of the year, and we have to explain why that happened and see if they fit within an exception. It could be a little difficult to prove as to why they weren't able to apply for asylum within the year of entering the United States. If this is granted, if asylum is granted, then you're given a work permit, and then after a year, you can apply for a green card. DACA. This was something that was given or announced in 2012 under the Obama administration by the Secretary of Homeland Security. It basically also provides some sort of protection against being like imminently removed from the United States. And it's for the young individuals that came before they turned 16, before June of 2007. This gives them the ability to have a work permit, have a social security number, and sort of be able to go about a more regular life in the United States. Some are able to go to school and practice in the field that they have wanted to practice without status being an issue. So this is a pretty big deal. It is renewable after every 2 years. Currently, I believe they're only taking renewals, and they're not taking the initial applications. Oh, right. No, you can submit the initial applications, but they're not approving them right now. There are a lot of injunctions going on, and it changes a lot from time to time. So what does undocumented mean? If you're undocumented, you can be a visa overstay, which means that you had sort of like all the paperwork necessary in order to come here to enter the country, but did not leave at the time that, the visa said you were supposed to leave, or that you violated, those terms of your visa. There's sometimes other requirements. And then you're undocumented if you cross the border without inspection. And this includes if you used any false documents. So who can be removed or who could be deported? It's basically anyone that is not a U.S. citizen. This includes, and I know this could be very surprising to some to hear, that even those with status can be deported. Those that have been here for many, many years as green card holders or permanent residents, they can be deported based on, for example, if they were convicted of a crime and that brings about a consequence with immigration, they can be deported. People who entered with visas can be deported because that's like a temporary status. And then people who entered without documents, who entered across the border, swam the river, came through water without like the proper channels, or going through CBP. So how does the removal case begin? So basically it starts with a notice to appear. They have the charges, the allegations and the charges there. And so it's just like in criminal court, that's basically like the charging document. And it tells you under which law in immigration that you violated. And so then we take pleadings, and here, that's not exactly true, this second point. There is no right to counsel as far as like the government having to pay for an attorney for you. So you have a right to an attorney, You just have to pay for it yourself. So that's a big difference between criminal and like civil. In criminal, the government is required to provide one if you cannot afford one. And so this is where our program comes in. Knife Up, we receive money from the city in order to provide this representation to detained immigrants. So once you have a case, or once the case has started, this is the phone number that we give folks to call to see when the next hearing is scheduled for. So it's a 1-800 number, and it's just like automated, and it gives you like very basic information. It tells you the status of a case, when the next hearing is, and if there's an order that has been issued. So what happens if you're already ordered removed? There are a few things that can happen. You can file a motion to reopen proceedings. So basically try to reopen the case and give an explanation as to why it needs to be reopened. You can request an emergency stay. So if it's like imminent removal, you can put that in. And it also depends on the way that you are removed. If there's an order in absentia, which means that you weren't actually present at the hearing, there's like some relief or some options that can be done with that. Or if you were ordered removed after having a full trial, for example, we can appeal with the Board of Immigration Appeals and run that course as well. So note of warning, beware of the notarios and the people who are not qualified to practice immigration. I've actually had a lot of clients that have gone to the notarios, and I've seen so many mistakes. And it's a mess to try to fix. And so our advice is definitely go to somebody who is qualified, go to a lawyer who is licensed to do this, because there can be mistakes that will be difficult to fix. Detention. Many immigrants are subject to mandatory detention under INA 236C. So depending on what ICE has determined as a danger, like if they see them as, based on their criminal history, they are a danger, they're convicted under something specific, then they put them in mandatory detention. If not, then we can ask for bond before the immigration judge and ask the judge to release the client and allow the client to continue the case while not detained. We could also ask for parole. That's basically in their discretion as well. There's so much discretion from judges and DHS ICE, which makes it very challenging at times. And of course, we have to demonstrate that they're not a danger to the community, and that they're not a flight risk, that they will actually show up to their hearings. This is information for when you need to locate someone that you believe has been detained or has been detained. This is our number, our hotline that you can call to ask for assistance. And I can share that later as well. So now I'm going to get into the Know Your Rights portion of this presentation. If you're stopped by the police or by immigration, these are the things that we are recommending that you not do. So do not give information about your immigration status. Do not lie, because it can bring a consequence to that. So also don't carry any false documents or IDs. Don't carry any documents that are related to your home country, because the government can use that against you, against the person, and say, oh, look, this is proof of alienage. This person is not from here clearly because they have this ID from another country. So we recommend that you carry the ID NYC. If you're stopped by the police, you want to have a phone number memorized, of an immigration lawyer, of a community org, or the consulate, your designated consulate. don't sign anything without you knowing exactly what you're signing. And if you need an interpreter, you have to ask for one, or you should ask for one, so that way you are understanding what is being presented to you. Many times it could be that you're signing away your rights to something like a hearing or for bond. And this is for situations when ICE is actually at the door. The first thing we want to know is if they have a search warrant. And the search warrant can't just be by ICE, it has to be signed by a judge. And so if there is no judicial warrant, then you do not open the door. You do not answer any questions. However, if they do have a proper judicial warrant, you can, you should open the door, but remain silent. You do not have to speak to them. You do not have to give them information about where you were born or anything related to your immigration status. And of course, the advisal is either way, you have the right to remain silent. These are the levels of police encounters that we actually see a lot with our clients. So it can be as casual or simple as conversations in the street where the police are just coming up to you and asking questions. And so just make sure that you're able to respond and say, am I free to leave? And if they say yes, then leave. This other category is like stop detention or stop and frisk. So the police are able to pat you down if it is considered a stop, but you still have the right to remain silent. And if you're in custody or if you're arrested, you want to ask for a lawyer and remain silent. So just this is a recap. Right to remain silent is important to exercise that right. To not open the door and not let the police come in unless they have a search warrant that's signed by a judge and not just by ICE. And this is another word of caution. City agencies are not supposed to ask about your immigration status unless it's actually related to what benefit you're seeking, and this does include police. And then if you're able to consult reach out to your consulate. So this is some more information, a little more specific to those with children. This is something that our organization does as well out in the community. We've done a few workshops pre-COVID. Not really sure if they have any now, but this is something that is very useful in case the parent is detained or deported. So you want to have available and ready the passport of your children, the school emergency contact form, standby guardian designation. So basically who would be in charge of your child if you're not around, designation of a person, the parental relation, a power of attorney. These are all documents that you need in order to basically be okay or have your children be okay. And then also a guardianship or a custody petition in family court. So within legal aid, within immigration law unit, we have projects that focus specifically with the youth. That's not my project, but they definitely know a little more. So this presentation, we've concluded the presentation, and this is my contact information. And I think I'm ready for questions. Oh, sorry. So the first question we have is, can I be legal being a teenager but with immigrant parents? And the answer is yes, because we in the United States have birthright citizenship, which means that if you are born in the United States, then you are automatically a citizen. But it is possible to still have parents who are undocumented because they were born in another country. So next question. If I'm sponsoring someone from my country to get a green card and they currently have a US visa, can they still travel to the US once they are sponsored, or do they have to give up their visa? So it depends, but it's probably best for them to wait for their green card interview at the consulate, and they should not travel on a non-immigrant visa if they have the intent of the immigrant. So that's the answer. Next. Can I apply for residency due to the fact that I have children above the age of 18 and being a victim of a crime? So, as a crime victim, you might be able to apply for a U visa if it's one of the qualifying crimes, such as felonious assault, domestic violence, sexual assault, rape, etc. But you need certification from law enforcement that you were the victim and that you were helpful in the investigation and or the prosecution of the crime. So this is important because I think this is another very common question about the children. If your children are U.S. citizens, so if you have a U.S. citizen child who is 21 years or older, then they can apply for you. So what it means is that if they're 18 years old, they cannot apply for you until they turn 21. So there's a bit of a gap there. And then whether you can get your green card here depends on whether you entered with inspection, admission, or parole, or whether you came EWI, which is without inspection. Next. If I can't apply for citizenship with the help of my child, what other way can I apply? So there are various options, and I think that we covered a lot of those in this PowerPoint. So just the first or second slide that I presented, those are the different ways that are available for individuals who have children. Next. How should I go about applying for citizenship after being in the US for over 20 years? So first, you need to become a lawful permanent resident. And that's because long-term residence is not enough for LPR status. And so through registry, you can apply for LPR status if you came before January 1st of 1972, which that's about 50 years ago. And unfortunately, just probably not a possibility. But once you are a lawful permanent resident for about 5 years, and there's some exceptions to that, then you can apply for citizenship as well. Next. How can I bring my family of 5 from Haiti to New York? So the option would be the immigrant visa petitions if you are a U.S. citizen or a legal or lawful permanent resident. And of course, the relationship also has to be there. You can't just have like a very far removed relative. It has to be within the categories that they designate. Next. How should I go about applying for citizenship after being in the US for, I think that's the wrong question. We've already answered that one, but I have it here. Is it true that judges get docked pay if they go through cases too slow? So the answer is no, but they might not get raises. They do have something called performance metrics, which means that they have about 700 cases per year, which averages out about 4 cases a day, meaning that they do have this incentive to rush through cases. And obviously it becomes a real challenge for the lawyer and for the client to feel like they were given the right amount of due process. So I think those are the only questions that I have for now. I don't know if there are any more. Oh, So we have a question here, and I also want to just tell the audience, when you're asking your questions, please don't give me sensitive information or confidential information. Just try to make your questions as general as possible. But the first question here we have is, what are those designated family relationships? So as far as like who can you petition, so you have to, if you're a U.S. citizen, you can petition for your spouse. So if you were married, if you have adult children, it could be a sibling or it could be a parent. If you're a lawful permanent resident, it becomes narrower, and it's only to petition a spouse or a child, but the child cannot be married. So those are the categories. Thank you. More questions? Okay, if there are no more questions, I'm happy to pass the torch.
Thank you so much for that, Ms. Gordillo. This was very informative. I know that I learned a great deal today, and so I just want to thank everyone who asked questions ahead of time, anyone who asked questions during the event. We will continue this partnership for sure. We're hoping to have events like this more often, maybe a couple of times a month, that we're able to translate for parents so that we're able to really target families in their native language. And so we're excited to really build the partnership together. And so I also want to thank Dr. Jamila Davis again and Angelo Pinto for helping us put this together. This was great. We hope that it was helpful to people. Have a great evening. Thank you.
Mm-hmm.